Today we are reading about Order 9, Rule 13. What are the remedies available to the plaintiff in case of an ex parte decree? Now, when the plaintiff is present in the court but the defendant is not present, then the court, after hearing the plaintiff only, passes a decree. It is called ex parte decree. Ex parte decree is not invalid. It is voidable if the defendant applies for it to set aside the ex parte decree. In case when an ex parte decree is passed in favor of the plaintiff, the defendant has many remedies. First of all, the defendant can move for an application under Order 9, Rule 13. Secondly, the defendant can move for an appeal against such a decree under Section 96, Subclause 2. Thirdly, the defendant can go for review. And fourthly, the defendant may file a suit on the ground of fraud. Now, let us have a deeper look in the Order 9, Rule 13. One thing that I need to mention here that all these remedies can be taken concurrently, and then in practical life it is upon the discretion of the court and upon the facts and circumstances of each cases the courts will decide which remedy can be more appropriately taken by the defendant, and the defendant will act accordingly. But it has been said in Bhanu Kumar Jain versus Archana Kumar 2005 that the two remedies, first Order 9 Rule 13 and second Section 96 Subclause 2, which is appeal against that ex parte order, can be taken concurrently. This is a landmark judgment which is defining the defendant's position in appeal and application against the ex parte order. It's time for reading the bare act. Order 9 Rule 13 says that setting aside decree ex parte against defendant. This is the marginal note. The marginal note makes it clear that first the decree must be ex parte and the defendant has this remedy of Order 9 Rule 13. The defendant specifically, not the plaintiff or any other person. In any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside. So the ultimate motive of the defendant is to set aside the ex parte decree. And to set aside the ex parte decree, we have already discussed there are 4 grounds that he can take. So Order 9 Rule 13 is one of that ground where he may apply, where the defendant may apply. Now moving on to the next part. And if he satisfies the court, so it is upon the discretion of the court that whether the court will set aside the ex parte decree or not. The point is the defendant has to satisfy the court on certain conditions or on certain points. And if he satisfies the court, there are 2 grounds. First, the summons was not duly served. Second ground, or that he was prevented by any sufficient cause from appearing. So these are these 2 grounds, that the summons was not duly served. As you know, in Order 6, a suit may proceed ex parte in favor of the plaintiff if the plaintiff proves that the summons has been served to the defendant and it is duly served, but the defendant is not present in the court. So Following the natural justice or the alteram partem, if the defendant proves that the summon was not duly served, then what the court will do, if he satisfies the court will set aside the decree, ex parte decree. And secondly, if the defendant shows that there is sufficient cause for his non-appearance, then the ex parte decree will also be set aside. What is exactly this sufficient cause is, it is not mentioned anywhere in the code. But by reading various kinds of case laws and commentary books, I have come to this conclusion that sufficient cause depends on case to case facts and circumstances. Now, the sufficient cause in one case may be the late arrival of the train of the defendant. It may be any kind of accident which caused to the defendant, or it may be illness or any other uh, kind of things. Now the court will test whether the defendant was honest and whether the defendant tried his best to be present at that time of hearing. Now, if the court is satisfied in these conditions which is given by this defendant, he will definitely set aside the ex parte decree. Now, while setting aside this ex parte decree, what the court may do, the court may impose kind of cost or payment to the court. So the bare act reads that the court shall make an order setting aside a decree as against him upon such terms as to costs, payment into court, or otherwise as it thinks fit, and, and shall appoint a day for proceeding with the suit. So, when the court sets aside an ex parte decree, he will also appoint a further date to proceed with the suit. There are two provisos given in this Rule 30. While reading the first proviso, provided that where the decree is of such a nature that it cannot be set aside as against such defendant only, it may be set aside as against all or any of the other defendants also. So, to simplify it, let's take a situation that there were four people, four defendants, and one of them sets aside this ex parte decree by proving, by satisfying the court on these kinds of grounds. But the suit is of such nature that the four people, their rights, liabilities, that are very much interconnected, and we cannot separate one person's right and liability from the another. So the suit is a kind of inseparable in nature. The interests of all the defendants are inseparable in nature. So in this case, when one defendant proves that the suit, that setting aside, there will be setting aside a decree, and if the court gives a set aside of decree, it means that for all the defendants the ex parte decree will be set aside. So the bare act reads that where the decree is of such a nature that it cannot be set aside as against such a defendant only. So it is an inseparable kind of nature. So for only one defendant we cannot set aside the ex parte. We have to set aside for all other defendants. So it reads, it may be set aside as against all or any of the other defendants also. The second proviso makes it very clear that The court will not set aside a decree merely on the ground of irregularity of the service of the summons. If the court is satisfied that the defendant had the notice of the date of the hearing and had sufficient time to appear and answer the plaintiff's claim. So, if the court sees that the defendant has willfully neglected his duty, this is the meaning what I am talking about. The defendant had the notice of the date that on this date I have to be present in the court, and he had sufficient time to do his duty to be present at the court, but he neglected. This notice was served to him. The notice was served to him, but there was some kind of irregularity. It may be on his title, okay, or some kind of thing of his address, but the notice has been served to him. He has the knowledge. The defendant has the knowledge. Now, if the defendant has the knowledge that I have to be present at that time on the court, he cannot deny it. Later on, he cannot take this plea that the summons was not duly served. There may be some kind of irregularity, but only on those mere irregularity the court will not set aside an ex parte decree. This is a very important proviso. If we read the explanation, the language may seem complicated, but I shall simplify you for your convenience. The simple meaning of this explanation is, if someone has already filed an appeal against the ex parte decree, so we knew that there are different kinds of remedies available to the defendant. One was appeal under section 96 subclause 2, subsection 2. If the defendant has already filed an appeal against that ex parte decree and that appeal has been decided by the court, by the higher court, because an appeal can be filed in a higher court, then they cannot come back and just file an application under order 9 rule 13 to set aside that same ex parte decree. So it is very much evident that the law does not want a person to get two chances to challenge the same ex parte decree. There will be multiplicity of the suit and there will be double proceedings. There may be conflicting judgments. To avoid these kinds of double proceedings or conflicting judgments, if an appeal has been decided, because these kinds of remedies are concurrent in nature, we can take it simultaneously. But if one appeal is decided by the higher court, then there is no point to go to order 9 rule 13. One thing that I need to add is order 9 rule 14, which says that no decree to be set aside without notice to opposite party. That means if the defendant wants to set aside an ex parte decree, he has to give the plaintiff notice, that is, following the principles of natural justice, hearing the other party. Without giving a notice to the plaintiff, a defendant cannot set aside an ex parte decree. I hope now setting aside decrees of ex parte is somewhat clearer. If my efforts has given you some color in your understanding of this order and rule of setting aside ex parte decree, then please hit that like button and subscribe the channel to know these kinds of things more and stay connected with me. You can help me out by subscribing that channel and sharing it to one of your friend at least. Thank you.